Non-technology founders who are paying a software agency to build their product need to look out for two things when it comes to ownership of their MVP, one of which is pretty well known and the other of which is much less well known. This came up on the weekly live stream that I do at 7 PM Thursdays UK time, so please join me for that next one of those I do. And I did a short straight after on the first aspect we're going to go through today, but the second aspect is so complex I've had to do this longer post to fit it in. The thing that doesn't usually come as a surprise is that you need to get the source code of the software that is built. The idea that you need source code is reasonably well socialized and people tend to know this. So to understand what source code is, software is built as two pieces. There's the software that you download and install on your device if it's an app, or the software you install on the server and access via a web browser. So that type of code, for simplicity's sake, we'll just call the installable code. You can't change installable code, you can only install it and run it. So installable code is created from source code, and this is the actual stuff, and this feels like a gross oversimplification, but actually it isn't. This is the actual stuff that someone physically has to sit down in front of a computer and type in. You cannot change the software without the source code, so if you're buying source code from an agency, you ultimately will want to change it as you want to add new features or you find bugs. Notionally, the installable code is like a PDF that you can read on the screen or print out, and the source code is like the Word document used to create that PDF document. Make sure your agency gives you the source code. You can find yourself in a situation where agencies will try and hold you to ransom over this. And if you're watching this because you are being held to ransom or think that you're about to be, you already have a problem you need to deal with. You need to get immediate advice and support. So in the contract between you and the agency, there should be some mechanism by which the source code comes to you. And oftentimes that's related to whether you've paid the bill. See my earlier point about being held to ransom. The second issue that is misunderstood by the majority of people, even CTOs with 20 or 30 years experience, is that of intellectual property transfer. Now, I'm not a lawyer and this isn't legal advice, but what this is though is me telling you that most people who think they know what they're doing and how this works will stagger backwards in horrified surprise when faced with the reality of how much more complex intellectual property transfer is than people think it is. As an overview, the issue with intellectual property transfer is that the agency building your software statutorily will own the intellectual property rights to that software as they create it. In order for you to use it, you either have to have those rights transferred to you, which is 100% the most ideal situation that the rights are transferred, or you have to be granted a license to benefit from those rights. Now, these days, people don't tend to really muck around with granting perpetual licenses and the IP is still owned by the agency. Realistically, most of the time, there is a transfer that has to happen. Now, normally in the contract with the agency, you will see a clause that says that the agency intends to transfer this right once certain milestones are passed. In the drafting of those agreements, it doesn't normally make the intention that explicit, and that's where people can get caught out. The very common milestone is one when the invoice is paid, e.g., when you pay this invoice, the intellectual property will be transferred. However, the fact the contract talks about intent is not enough. There has to be a formal and explicit transfer of intellectual property in order for those rights to transfer from one party to another. This is the bit where people get bitten, even people with loads of experience, because they think that the agreement is enough to perform the transfer, and it normally is not. For example, and this has happened to me twice, the customer commissions the agency to write some software, and they agree that when the invoice is paid, the intellectual property will be transferred. The agency writes the software, issues an invoice, the customer pays the invoice. 5 years go by and the customer wants to sell the business, and the commissioned software is classed as an asset to be included in that sale. The lawyers for the buyer look at the software and look at the agreement, and then they say to the customer, who's trying to sell their business now, well, the right's still lodged with the original agency, the supplier of that code. The problem here is the uncertainty, and the uncertainty comes from how these clauses are typically drafted. Without an explicit transfer, there will always be uncertainty as to who actually owns the intellectual property, regardless of whether those milestones have notionally been passed or not. The reason why is because when you're going through a sale of the business in order to effect an exit, you can end up with the supplier, I'm going to say, playing games, right? So if the supplier hears that the customer has been bought by a much bigger company, they may be minded to try their luck by applying to the High Court for an injunction to prevent the software from being used. I've also seen this happen once when a company I did some work for was bought by a major supermarket in the UK. So imagine this happens post-sale. Unless the new owner can show that the agency explicitly transferred that intellectual property when the agency goes to the court for injunctive relief, the court may grant that injunctive relief. Then this is where the risk comes in, because the new owner doesn't want to find themselves in this situation. They've bought the business, hopefully from you for loads of money, but they want to be able to use it. So the court may grant that injunctive relief, and at trial the court may be with the agency that the rights are still with them, in which case the new owners would have to go back to the agency and seek some transfer, which could end up costing them a whole load of money. This one is really easy. Whatever you think is happening with your IP transfer is not what is happening. In every case, even when you think you've got this sorted, you need to go and find a specialist intellectual property lawyer and get them to come up with a framework whereby both parties can properly achieve and record proper transfers of intellectual property as the project proceeds and is completed. So to put it more simply, don't trust that whatever you have in any agreement you have with the supplier is actually effective at realistically transferring the intellectual property if somebody is feeling adversarial. So let me tell you a secret. I have something called the VIP program, or the Very Important Founder program. There's a link in my bio where you can go and sign up. And when you do, you get access to free training, ebooks, checklists, exclusive content, all manner of resources that help you as a non-technology founder start and grow your technology business. Why don't you nip over to my bio, follow the link, sign up, and I'll see you there. Thanks for watching.